Okay, great. Well, good morning, everybody. Thank you for joining us this morning. I'm Celia Meyer with Title Connect Agency. I'm just going to go through a couple of the we're calling it Title 101, but just sort of some of the important things to know about title insurance, and as you're going through the title process, things you can sort of expect. So the lovely Kristen Hart is going to be running the PowerPoint for me. Thank you for that. So we can go ahead and go ahead and go to the next slide.
Maybe I have to, oh, can you see it?
Nope.
Nope. Great. Hold on. Okay, I need to go back to screen share. Okay.
Yep, there it is. Perfect. Okay. So I understand everybody can read. I'm not going to go through and read this exactly. I'm just going to kind of hit some of the high points here. So title insurance, that is specifically American. We are one of the major people who actually use the title insurance. So title insurance is going to be protecting you from things that have already happened. So it's not going to be anything similar to homeowners insurance where you're protecting against what might happen. It's going to be for things that have already happened in the past. So it's going to reimburse the insurer. It'll be reimbursement for things that you've lost, for things like legal expense. If let's say somebody comes to you and says, okay, this deed was not transferred properly, I actually have ownership of this property, things like that. So that's one of the reasons title insurance is so important to get, especially if there were a lot of transfers in the past, or potentially was an inheritance, there might be a dispute over who actually owns the property, things like that. Title is where title insurance steps in. We could go ahead and go to the next slide. So do I need title insurance? That's a common question that people ask. If there's a couple of different situations when you might not be required to get title insurance, specifically if you're purchasing in cash. If you are purchasing in cash, there's not a requirement to purchase it. However, if you're purchasing with a lender, there will be a requirement to get title insurance. In both instances, an owner's policy is not required. The owner's policy protects the person who actually owns the property. Whereas if you're working with a lender, there's a lender policy that would protect them only. But the question of, do I need title insurance? It's one of those things that I personally, when I purchased my home, even knowing the search was clean on the property, I still purchased the title insurance policy because it's a one-time purchase that is a nominal fee compared to the price point. And if you don't have it, it's typically going to be one of those things that you're going to regret not having. You know, it's like I mentioned, it's going to actually make sure that property is yours. So while it is a decision to get the homeowner's policy or not, it's sort of one of those things that I would personally never not purchase it. We talked a little bit about the lender requiring title insurance. So that does not protect the owner, though. It only protects the lender against the lender's amount that they have loaned. So if, let's say, somebody comes to you saying, you know, this property was transferred incorrectly, my father was supposed to transfer it to me upon death, you know, then in that situation, the lender would be protected and the lender would be reimbursed for anything they lost, but you, the owner, would potentially not be. So that's why it's important for you to go ahead and get that title insurance policy. Okay, go ahead to the next one, please.
It's not moving now.
Of course.
Why was it so easy? Oh, there we go.
Okay, so how much does title insurance cost? That question is a very common question, and it's a good question. So title insurance is set by the Ohio Department of Insurance. So the policy is going to cost the same amount regardless of what title insurance company you go through, and it is based off the purchase price of the property. In front of you, there's a scale of how that's configured. You don't necessarily need to learn this and know exactly how to configure that yourself. I just want you to be aware of it. So the way this happens is, let's say you have a property that is, you know, $250,000, you would take that first $150,000 and times it by the 575 per thousand. And then that next 100,000 would be charged at that 450 per thousand. So you can't really say, okay, it's, you know, a $250,000 property, it's going to be 450 per thousand. It's a sliding scale. So it does vary based off your price point. So just something to kind of be aware of. And then there is a minimum charge. Let's say you have a plot of land that's, you know, $7,000 or $8,000. There's going to be that minimum $175 charge for the policy. The other thing that to be aware of, and this is very helpful when you have sellers, is there is a reissue rate available. If you purchased the home under 10 years ago, you, the seller, are eligible for a discount on the policy. It's typically going to be around 30% of the policy amount that you would save. And the only thing you have to do to get that discount is provide your prior title policy or those numbers pages. Would it be the HUD or the settlement statement? Who pays for title insurance? So that's going to vary based on where you are and what contract you're using. Here in Columbus, our Columbus Board of Realtors contract says that the seller pays for the title insurance policy. Now, keep in mind, that's because of the contract we're using. So let's say you're in Dayton, it's going to be a little bit different because their contract calls for different payment. So in Dayton, the buyer pays for the title policy. So it's going to be contract specific. So you can't really say, okay, the seller always pays for the title policy. You just have to be paying attention to what contract you're using. Next slide, please. Okay, how to get to closing smoothly. This is I'm just going through some of the things that are something to keep in mind as you're working through this. So you get a listing. A pre-start is where we go ahead and do the search on the property, and we find out if there are any judgments or liens that we need to be aware of. Very typical judgments or liens that you're going to see on the property are going to be your mortgage and any taxes. So in Ohio, taxes are paid in arrears. So typically taxes are always going to be a lien on the property as well as the mortgage. Other things that could be on the actual search that comes up showing us what needs to be paid off are things such as any, let's say there are back taxes that you owe to the IRS, things like that. Those would show up as well on the property. So we're looking for anything like that. Typically things will show up that might be the same name as your person or you. The title company goes through and actually just clears those off if it's not that person. But that's why a pre-start is a good thing to do. It gets you that information on the front end. It does not cost the seller any money to do the pre-start. That just gets the process started ahead of time.
Celia, can I ask a question?
Please do.
So for instance, the situation I'm in,
Yes.
what would have been my seller's options if we would have already listed? Because we did the pre-start and this has been kind of going on for probably a couple months.
Yes.
So what would have happened if we would have already listed?
So if you had already listed, you already had accepted a contract and you're in contract, the problem would be the date. You would potentially need to extend out your contract. So just to kind of give an overview, guys, of what Kelsey's asking. So she has a seller who asked us to do a pre-start before listing because he thought he might have some additional liens on the property. We went ahead and did that search and we did find there were additional other liens. Some we are determining if it is actually him. And then we're working on trying to get those cleared. So the thing with yours, Kelsey, with some of those being attorney general liens, those typically are going to take a minimum of 2 weeks to get payoff information from the attorney general. So with situations like that, it's a time thing, really. The attorney general a lot of times won't necessarily speak to us directly. They require the seller to call and give the information needed. So it's really just trying to be timely with your closing, and then also knowing ahead of time how much it's going to cost. Let's say the seller is going to net $100,000, but he has $150,000 in liens. Those all have to be cleared. So then the question to him would be, do you have $50,000 extra to bring to closing to sell this property? So so that's why it's important to kind of know ahead of time what you're getting into as far as when you sell the property. Did that answer your question?
Yes, thank you.
Okay. Yep, no problem. Okay, so on to the next one for contracts. So let's say you're working with a seller, you've accepted a contract from a buyer, you're now in contract. The next thing you would do is go ahead and send to the title company that contract, and then just some basic information to make things start moving along for the title company, such as contact information for the seller, and then the buyer's agent's contact information, and then your commission amount. Things like that will go ahead and get things moving. We'll reach out to the seller and then the buyer's agent to get contact for the buyers. At that point, we start kind of working behind the scenes, getting the search done on the property if it wasn't already done as a pre-start, which we always recommend. But we'll work on the search. We will order payoffs, things like that. The next one there, the title commitment. So the title commitment is important because it's part of the contract. So per your contract, and again, this is going to be contract specific, but per your contract, the seller is required to provide to the buyer the title commitment 15 days prior to the closing date. Now, obviously, there are situations, maybe cash typically, where you might have a closing date that's fewer than 15 days. So in that situation, there would need to be that understanding that it's obviously not going to be 15 days prior. But the seller providing that to the buyer being a requirement, if it has not happened 15 days prior, the buyer can use that as an out from the contract. So they can say, you didn't uphold your end of the bargain here. We no longer want to purchase this property. So that's something important to remember. And it's up to you, the agent, how you want to handle that. You can have the title company send it to the buyers directly. You can have them send it to your seller and then you send it over from there. That's just going to be up to you how you want that handled. But that's something to keep on your calendar, maybe at the 15 or prior to 15-day mark. Just kind of remember, okay, has this been sent over already? The seller pre-sign. So I put this in here because sellers do not have to close the same day as the buyer if they don't want to. So sellers a lot of times can actually sign their paperwork early. And that's just convenience. It makes it sometimes easier for them to schedule, or sometimes if they're moving out of state and they want to get it done before they move, things like that, you can go ahead and sign early. And then if anything changes in the figures, we can send the updated figures to them without them having to reappear in person. But there are documents that the seller signs that do have to be notarized, such as the deed. So it's important for those to get done in person. The buyer signing, if there is a lender, that's going to be dependent upon when the lender is cleared to close and when they go ahead and okay us to schedule that. So, so that's typically going to be on or before a close date, and if it's not, then you have to file an extension. But that is going to be up to the lender, and then typically the seller has already closed at that point, or if they choose to close with the buyer, they can do that as well, but they're not required to do roundtable. Actually, we're not doing a lot of roundtables right now with COVID, but prior to that was happening a little more frequently. The commission checks, there's a question of when do we get those commission checks, and then also the next one there, the seller proceeds. So when do you receive those? So those are going to be distributed once everything has been completely finished signing and the lender has given funding approval. So if there's a lender involved, they typically want to look at some of the documents and say, okay, we're happy with how that was signed. And then they will give us the okay and say, okay, you've satisfied everything we need. Go ahead and give out checks and you can pay the seller. Typically that's going to be the same day. If it's the end of the day, sometimes that'll push into the next business day. Okay, next one, please. Any questions, anything I've gone over so far? Okay, the escrow process, this is just kind of giving you a little bit of a background of what we do, just so you can kind of have an idea of what's happening behind the scenes. So, so I mentioned already, once you send the contract over to us, at that point, then we set up an order and we assign a file name to it. We reach out to all the parties, buyers, sellers, if there's any attorneys involved, the lender, all of those parties, we let them know who we are and kind of what to expect in the coming weeks as we're going through this process. If the search wasn't already done as a pre-start, we go ahead and order the search. We schedule the survey if there's a survey required by the lender or if the buyers are choosing a survey. We will order the payoff if there's an existing mortgage. Those typically take a little bit of time to get from the lender, so we order those on the front end. The buyer is going to go ahead and set up their hazard insurance. That's going to be their homeowner's insurance. Lenders refer to it as hazard insurance, though. And then we will collect any invoices. So if the seller is making any repairs to the property, if there's a home warranty, anything like that, we can collect those, and then we pay them from the settlement funds at closing. So the seller's not required to pay those during the remedy period. They can just have it invoiced in as long as the contractor doesn't require payment right away. We work with the lender to balance numbers. So the lender provides numbers to us. We provide any of our numbers to them, things like payoff, anything we've found. And then we balance those numbers together so that everybody's on the same page. And then once we get closing packet and document from the lender, then at that point we can go ahead and schedule the closing. And then once the closing is finished, we go ahead and disperse the money everywhere it's owed, both to any realtors involved, seller, if the seller's receiving proceeds, and even buyer occasionally will have sent too much money or might be receiving money back. We'll go ahead and disperse that money out. And then we get the documents recorded. The mortgage will be recorded, the deed will be recorded, and then any of the other documents like a power of attorney or a transfer on death, anything like that, those documents would all be recorded. And then once it's been recorded and returned to us, we send the deed out to that buyer. We also include the final title insurance policy. So that's going to be that policy that protects them from any prior owners and makes sure the property is theirs. What the buyer and seller can expect at the closing table is going to be that the settlement agent, so that's going to be typically somebody from the company, the title insurance company. We're going to sit down with the buyer and seller. We're going to go through the documents with them and explain what each document is, and then just ask if they have any questions or anything that they don't understand. And then they're just going to sign all their documents. They always need to be sure to bring valid ID. And then sellers, if they are getting their proceeds wired to them, we ask them to bring a voided check for their account that they want it wired to. Whether or not you're required to go to closing is completely between you and your client. So there's no requirement for you to be there. Most agents like to be there because obviously it's an opportunity to get more face time with your client, but there's no requirement. It's completely up to you guys. All right, on to the next, please. Okay, typical charges you can see on a settlement statement. So each title company is going to be a little bit different in what they call their fees, as well as in the total cost of the fees. Now, the title insurance fees that that title company charges are going to be the only thing that should vary from title company to title company. The title insurance policy will be consistent. Taxes that are being credited to the buyer is going to be consistent based off closing date, as well as any conveyance fees, which are the transfer tax from the county. Those shouldn't change. Those should be the same regardless of who you're working with. The fees themselves are the title company charges. Those will vary from company to company. In our area, there's not a ton of variance. We're talking typically around $100 between company to company. But everybody's a little different. But this list of fees are things that you can look for that are just standard fees and shouldn't be alarming. So the settlement or closing is going to be typically on there. The title binder or the title commitment, again, that's that commitment that you have to get to the buyers 15 days prior to closing. It can be called either commitment or binder. Courier or shipping fee, that's going to be the same thing. The wiring fee or wire processing fee is the same. The title search, a lot of companies also call it a title exam. Your update fee, that is going to be, the title company gets that initial search, and then we do an update just prior to closing to see if anything new was added to that property. Closing protection coverage, or CPL, that's, and I'll go into that a little bit more in just a second here. The deed preparation, typically to an attorney. And then recording service fees that will go to the county. And then transfer tax is also called conveyance. So, just to step back again for a second, the closing protection coverage. Closing protection coverage is a policy that protects the buyer or seller from the title agent, which would be Title Connect agency, whatever agent you're working with. The closing protection coverage was put in place by the state of Ohio a few years back because there were some title companies that that were essentially not recording new deeds, not paying off mortgages, and just stealing people's money. So now the state of Ohio requires every single title agent to offer that policy. The policy comes from the underwriter directly and then protects against that agent. That's something you should be aware of and be able to explain to your client, but you shouldn't be advising them whether they should or should not purchase it. There's just some liability there if you say, no, you don't need it, and then the title company happens to do something that, you know, costs them the money, they're going to come back to you on that. They will be required to purchase closing protection coverage if there's a lender involved. It'll be a $40 policy that protects the lender. That does not protect the buyers. If the buyers want to purchase their policy, it's an additional $20. And then sellers, if they want to purchase the policy, it's $55. So again, if that's something that if they have additional questions on, they should call the title company and have the title company explain it to them further. Okay, on to the taxes. So county taxes are paid in arrears. So what that means is we're always a year behind. So in January of 2020, we paid the taxes that were for January through July of 2019. And then typically in July of 2020, which is what we just did, you would have your taxes for the second half of last year, July through December of last year. You pay that this year. So we're always behind on our tax payment. So a lot of times sellers want to know why they're giving money to the buyer for property taxes. That's because they owned the property for a period of time that the buyers are going to have to make a payment on in the future. So they credit that money to the buyer, and then the buyer pays it when it's due. Typically, the seller is going to say to you, I'm current on my taxes. I haven't fallen behind. I make all my tax payments. That's correct. And it doesn't mean that they've done anything wrong. It just means it's the way that our county is set up and the way our counties collect taxes in arrears. So that's something that typically gets questioned and a lot of times is a little bit confusing. Okay, next slide, please. Okay. How does the buyer get the funds to the title company? So the state of Ohio recently put into effect a law that says anything $10,000 or more has to be in the form of a wire. So $10,001 required to be a wire. That's including multiple checks. So you can't have a check for $5,000 and a check for $5,003. That would be considered more than $10,000. It would have to be in a wire at that point. If it's $9,900, it can be in a check. That, like I mentioned, it's a relatively new law, but it was put in effect because the state of Ohio wanted to protect against check fraud. The wiring instructions the title company sends out to the buyers, those are never going to change. So if the buyer gets an email from somebody that looks to be from the title company and it says, hey, we've changed our wiring instructions, please see our updated wiring instructions, that's a huge red flag, and the buyer should always contact the title company directly from the phone number that they initially received, not something listed in that email. And they should ask about that and say, hey, I received this, can you tell me what this is about? Typically that's going to be fraudulent activity. Additionally, you, the realtor, should never forward on wiring instructions. If the title company sends it to you and says, please send this to your buyers or sellers, I would recommend always saying, no, I'm not going to do that. You please send it to them directly and securely. Just adds additional liability to you guys if you're sending wiring instructions to them. Okay, so how does the seller receive proceeds? We touched on that a little bit in one of the last slides, but the seller has a couple of options if they're receiving proceeds. They can either get a check that's just written out to whomever the owners are, or we can wire to an account in the names of the person in title. So if it's a husband and wife in title, we could wire directly to a bank account in both of their names. If it's an LLC or a trust, same thing, it would have to be to an account in the name of the LLC or the trust. But that would be up to them how they want to receive that. If they do get the wire, typically the wires are going to be within the same day, depending on the closing time. If the sellers are closing earlier in the day, a lot of times they'll see those funds before the end of the day. If it's later in the day or holidays coming up, things like that, a lot of times it'll take a little bit longer and potentially be the next business day. Okay, next slide, please. Are there any questions so far? Okay. What does dower mean? So the state of Ohio is a dower state. There are very few dower states left in the country. I think maybe 6 states are still dower states. But what that means is if you are married, your spouse is required to sign off on the sale of your property. Now, this does exclude things like trusts and LLCs. That's not going to be the same for those types of property. But if it's a personal property, if you are married, even if, let's say you purchased the home 10 years ago, you got married last week, and tomorrow you're closing on a property, your spouse now has to sign off on that property as well. So that's something just to keep in mind. Anytime somebody is selling something, both spouses are going to have to not necessarily be present at the exact same time, but both will have to sign the documents. Another thing that I'm just going to hit on is if the buyer or seller is out of state, that's not a problem. The documents can be sent to them and a notary can be sent to them. You just have to keep in mind timing. So if the closing date is set for tomorrow, those documents would need to be set a day or two prior in order to get them back in time for closing to disperse funds. If it's not a timing issue, let's say the seller's okay with the funds dispersing another day or two later, then in that situation, it would be fine to receive those back the same day, but that's going to be up to the seller and buyer. Okay, next slide, I think is just one last thing I'm going to hit on here. Inducements, I just want to cover this for 1 second. Just something to keep in mind, you as the realtor, your license can potentially be at risk if you are accepting inducements or if you're accepting something that seems like it might be true. So if there's a title company or a lender that's saying, hey, I'm going to spend $1,000 every single month on your marketing, all you have to do is send me all your business. Something like that, just be cognizant of, because if they get audited by RESPA and then have to show who all they were spending money on and your license number pops up, you could potentially be liable for any of the things called into order there. So just something to keep track of, keep in mind, protect your license. So, that is it. That is what I have for Title 101. Kristen, is there anything that you think that we should add to this, or questions that somebody might have that I didn't cover in here?
I have a question just because I did real estate up in Cleveland, and I'm not sure if you guys do it this way, but at closing, so in Cleveland, in order for the buyers to get keys the same day, the closing that day has to happen at like 9 or 10 in the morning, because the title agents literally have to drive the deed
to the recorder. That doesn't happen here.
Okay.
Yeah, so Cleveland closes an escrow where they do have to physically get the deed to the recorder's office. We don't do that here. That's not a requirement in our area. The keys can be given to the buyer as long as the funding is approved and the seller has okayed it. So that's not quite the same here. We have more of a timeline where we can send the deed out. It doesn't have to be same day.
Okay.
Yeah, so good question though. Kelsey, do you have any questions?
I do not, but thanks for asking.
Okay, absolutely.
I have one more question.
Please, yes.
So let's say I'm working with a buyer and my buyer does want an attorney to look over the contract. Does your title company offer attorney services?
So title companies would not be able to offer attorney services only because there's a conflict of interest there. So because the title company is representing both sides, technically we're a neutral third party. If we were to represent one side, it would be a conflict of interest to the other. We can always offer recommendations, referrals of other attorneys, but the attorney in our office would not be able to advise or litigate for somebody if we're covering the closing.
Got it.
And that's going to be with any title company in town, just because they would have those same restraints there.
Got it. Okay.
But another thing that it comes up as questions a lot. Sometimes your buyers or sellers might need additional documents, things like a power of attorney. Let's say somebody's going to be out of town and one of the spouses is going to sign for the other. So they need a power of attorney prepared, or let's say it's an FHA loan and the other person, maybe you're planning to live with a second person and that second person can't be on the deed or the mortgage because it's an FHA loan. You might want to prepare a transfer on death so that that person is protected if something were to happen to the first person. Things like that we and typically any of the other title companies can help prepare during the process and execute at closing. Power of attorney, obviously, the first spouse would have to sign ahead of time, but it can be brought to closing and then recorded with the other documents. So some of those other things that need to happen can typically happen during the closing process as well.
Cool.
All right.
That was
Anything else?
so good.
Thank you. I mean, I hope that answered all the questions anybody has. And if anything else comes up, actually, if you would pop to the next slide, I just have contact information on there. If anybody needs anything, questions I can answer, something comes up, weird situation. We know those never happen, right? But
Nope.
If you've got a weird situation with some extra questions, please feel free to reach out to me, call, text, email, whatever's easiest for you.
Thanks for coming, guys.
Absolutely. Yeah. Yes. Thank you guys so
Celia.
much. We appreciate you all and hope to see you all in person again soon.
Bye.
Okay,
Bye, Celia. Thank you so much.
Absolutely. Bye.